This is Suchitra Vijayan, and you're joining us for the Polis Project's Conversation series. By August 31st, India could strip citizenship from as many as 4 million people in one of the biggest disenfranchisement efforts in the history. Joining us today is lawyer and researcher Darshana Mitra, who's going to walk us through India's political history of citizenship, but also legally break down what the National Register of Citizenship is. Darshana, thank you for joining us today.
Thank you, Suchitra, for having me over.
Darshana, can we start with a simple question? Who is a citizen of India?
Well, I suppose that's really the question that's at the heart of the NRC debate today. But if you look at the Constitution of India, there is a very clear scheme that's been laid down for who becomes a citizen of India. So when the Constitution came into effect in 1950, Articles 5 to 11 dealt with citizenship rules. And at that point of time, India had a very clear jus soli principle of citizenship. Now, jus soli basically refers to birthright citizenship. It means that if you're born in a particular territory, then you automatically, by virtue of your birth, become a citizen of that country. That is in opposition to the jus sanguinis principle, which refers to citizenship by descent, which means that if you are descended from the people that constitute that nation, for a clear example is Israel has jus sanguinis citizenship, which means that if you're of Jewish descent, anywhere in the world, you automatically acquire Israeli citizenship. And that was never really a principle that was there in the Constitution of India in 1950. And at that point of time, apart from jus soli or birthright citizenship, there were two other categories of citizenship. Basically, people who were domiciled in India, so people who had their residence in India, or people who had migrated or come back to India at the time of the partition. Now, you might remember, and all of us know that at that point of time, the partition was an event of great violence. And there was a lot of confusion among populations who lived in the bordering states. A lot of people left India, went to Pakistan, or came from Pakistan back to India. So in order to accommodate these migratory populations, Articles 5 to 11 accounted for movement back and forth on these settlement permits to even constitute an intent to stay on in India, and therefore you could acquire citizenship. Now, the reason I say this is because today when you look at the NRC or even the Citizenship Amendment Bill, what you're essentially looking at is a movement from the jus soli principle or birthright citizenship, which was basically a citizenship that was delinked from any idea of what is an ethnic Indian identity, to something that looks at more problematic ethnicity or religious considerations when it comes to determining who has a greater right to Indian citizenship. This isn't something that is just the NRC and the Citizenship Amendment Bill today, however. You've had scholars like Anupama Rao and Mirza Gopal, they talk about how there has been a subsequent enclosure of citizenship in India. So, for example, if you look at the 1986 Citizenship Amendment Act, it introduces Section 6A. Now, this is very important for the NRC discussion as well, because what Section 6A essentially did was introduce a separate category of citizenship, which was specifically for Assam. Now, to sort of understand how that works, maybe if we were to look at the structure of the Citizenship Act in India in general, in addition to the Constitution of India, which talks about who can be a citizen of the country, you also have the Citizenship Act of 1955, which lays down under what categories one can acquire or become a citizen of the country. Now, these are essentially 5 countries plus what's applicable to Assam. These categories are birth, descent, registration, naturalization, and incorporation of territory. What 6A in 1986 did was create a separate category of citizenship for people who had migrated from Bangladesh or East Pakistan at that point of time into Assam. Now, the context of this is that basically the Assam Accord, and the Assam Accord happened in the wake of the Assam agitation, which was basically a movement for social linguistic rights for Assamese people in the state of Assam because of the threat that was perceived and felt to the Assamese identity from migration from a lot of different people. There is a separate historical and cultural context to that, which we don't really need to go into. Apart from just to mention that there is a lot of validity to claims that are often made that the Assamese identity is under attack or the Assamese identity is at the risk of dilution. What the Assam Accord did was basically it was a agreement between the All Assam Students Union and the then Rajiv Gandhi government. One of the things it spoke about was that illegal migrants would be identified and gradually deported from the state back to Bangladesh over a period of time. Subsequently, the accord was signed in 85, and in 86 you had the Citizenship Amendment Act come in, which basically said that any person who had migrated to India on after January 1st, 1966, but before March 25th, 1971, would be considered a citizen of India. Persons who had come in after that period of time, which is basically 25th of March 1971 onwards, would be identified and deported from the country. The reason why March 25th, 1971 becomes an important date is because that is when Operation Searchlight was started by West Pakistan in East Pakistan, and that's also when the Bangladesh Liberation War started. And the understanding, of course, was that the starting of the war would start a huge wave of migration, which India didn't necessarily want to deal with. What this essentially does is that when Section 6A was introduced into the Citizenship Act, there emerged a requirement, emerged a necessity to identify these people who were coming in after this cutoff date and start deporting them. Now, whether or not that actually matches the reality of how migration works in the state was not really relevant. It was an arbitrary cutoff date, but it's a cutoff date that continues to haunt us till date. The last thing that I want to speak about the citizenship laws in India is the 2003 amendment that took place, which is also an example of how citizenship has been gradually closed off to certain categories of people. It introduced two major changes. One was, of course, the overseas citizen of India identity, which basically meant that if you were a person of Indian descent living abroad, you were a citizen of another country, you could still claim certain rights and privileges, although not full citizenship rights and privileges in India. It's important to note that India does not actually allow dual citizenship in its fullest form, but this was perceived and presented as a form of dual citizenship. The second big change that the 2003 amendment brought in, which people often don't talk about, is that it further restricted use solely citizenship to say that you could acquire birthright citizenship only if both of your parents were not illegal migrants. So if either one of your parents was an illegal migrant at the time of your birth, then even if you were born in India and your other parent was a citizen of the country, you could not acquire birthright citizenship in the country. And that was the 2003 amendment. What you're seeing over a period of time, and now with both the NRC and the Citizenship Amendment Bill, therefore, is really just a restriction of what it means to be a citizen of the country, excluding different categories of people, and creating a completely different conception of citizenship than was imagined at the time of the conception of the Constitution.
Darshana, now can you tell us about what the NRC is, how it operates, and what data does the NRC rely on to enumerate this list?
Absolutely. So, what is the NRC? Everybody keeps talking about the National Register of Citizens. It's really important to remember that India does not actually have a citizens registry. The Aadhaar does not count in this case. The NRC was created on the basis of the 1951 census that took place in India, which was the first census that took place in independent India. Even the data from that census is not really considered to be obviously any authoritative source on who was a citizen of the country at that point of time. However, the subset of data for Assam was considered to be the National Register of Citizens. Now, in addition to the National Register of Citizens, as was the data in the 1951 census, you also have the electoral rolls that existed in Assam on midnight of 24th of March 1971, which, as we remember, is the cutoff date that was imposed by Section 6A of the Citizenship Amendment Act of 1986. So, both of these data sets combine to create what is called as legacy data in the NRC. Now, in 2014, the Supreme Court in the case of Assam Public Works versus Union of India, which was filed basically to ask for the implementation of both the Assam Accord and 2005 tripartite agreement that was reached between the Assam state governments, the All Assam Students Union and the central government. So in this particular writ petition, the petitioners had asked for implementation of these agreements and the identification and removal of illegal migrants from the state of Assam. The Supreme Court in this, and the case continues to go on, and it is a case which is basically leading to the implementation of the NRC, asked for the NRC to be updated with full and fresh data about citizenship of all existing persons resident in Assam right now. And in order to do so, they relied on legacy data, which, as I mentioned, is a combination of the 1951 NRC as well as the electoral rolls. Now, in order to prove that you are actually a bona fide citizen of India, resident in Assam, you have to prove your connection to anybody whose name is on this legacy data. So it could be a father, it could be a grandfather, but you have to be able to essentially prove that you are directly either you're the person whose name is on either one of these data sets, or you're descended from the people whose names are on either one of these data sets. Um, all of this relies on documentary evidence. You have to have the right kind of documents. You have to have documents with the right kind of names, and you have to have really the entire your entire genealogy established in order to prove that you're actually a citizen of the country, which, as multiple reports have suggested till now, has been incredibly difficult for people to prove and acquire.
And that brings us to the problems of documentation.
Yes.
We've seen a lot of stories come out of Assam about the problems of documentation. Can you explain to us what is this problem of documentation, but also perhaps link this to the larger history of the problem of acquiring documentation, especially if you're poor or marginalized or live in the fringes of the state?
Absolutely. So, just before that, I think it's important to realize what is at stake here right now. What is at stake here is that in the last list that was NRC list that was published by the authorities, you had 4 million people who had been identified as effectively not having citizenship of India. Now, the final date for the list to be published is August 31st of this year, which means that by August 31st, we will basically get a definitive list of who are the people who are going to be considered stateless in India at this point of time. Now, why is this number so huge? I think one of the problems is primarily your documentation and the way in which citizenship is being directly linked to the documents that you have. As you remember, it is not sufficient if you yourself have a voter ID card or you yourself have an Aadhaar card. You have to be able to prove that you and your ancestors were present in this country before the relevant cutoff date. And multiple cases have emerged, innumerable cases as a matter of fact, where people have just not been able to prove the appropriate linkage, and the standards of proof are quite high. In fact, at this point of time, it's important to remember that unlike in most criminal cases, where the burden of proof is on the state to be able to prove that you are actually, a criminal or you're not a criminal, or you're basically guilty of what you've been accused of. The NRC, even though it's not a criminal process, the burden of proof is actually on the individual. So it is on you to prove that you're a citizen of the country. It is not on the state to prove that you're not a citizen of the country. The other thing that we need to remember is, again, the problematic nature of reliance on documents in a country where most people are illiterate and do not have access to the appropriate resources with which to maintain documentary evidence of their citizenship. Assam experiences floods every year, and documents get washed away in floods. It's really as simple as that. There have been multiple reports in multiple news portals which talk about how people are refusing to leave their homes because if they leave their homes, there's a chance that they may lose their documents. So they are taking on the risk of actually dying in the floods or having been swept away in the floods rather than be declared stateless by the state government. Just to get back into the nature of the documents that are required, you basically need two kinds of documents. There are two lists. There are Type A documents and Type B documents. Type A documents are documents which directly are to do with whether or not you or your ancestor were present in the country before the cutoff date in 1971. And Type B documents prove your linkage to your ancestor who was present in the country before 1971. This means that women and children are particularly vulnerable to the NRC process because often when women get married, they don't have appropriate documentation. Women historically in India lack documentation of identity, lack documentation of, say, like a voter ID card or an Aadhaar card, which could entitle you to several entitlements. Children in particular, the younger you are, the more line of documents you have to produce in order to establish a certain genealogy, which means that there have been cases, for example, where both parents have been named in the NRC, but the child has not been named in the NRC, which is frankly quite absurd. So I think there is this absurd insistence on documentary evidence is really one of the reasons why so many people are at the risk of being declared stateless in the country today. And I think it's also important to sort of remember here that what are the implications of statelessness? in a country like India, where it's very easy to say deport somebody, but where do you deport them to, right? Because you can't just deport somebody into thin air. You have to deport them to a particular country. And Bangladesh is not going to claim them. Bangladesh has obviously already refused to claim them. There is our evidentiary standards may be sufficient for us to declare somebody stateless. They're not sufficient for Bangladesh to accept that they're citizens of Bangladesh, which means that we're not going to be able to deport these 4 lakh people, 4 million people to a particular place. They're going to be in indefinite detention, and that is exactly what's happening in Assam right now. People are being put in indefinite detention, in immigration detention camps all throughout Assam. The strategy of how does one address the statelessness that's emerging from the NRC process seems to be put them in detention camps, we'll think about them later. The Supreme Court, in fact, has been particularly resistant to even the idea that some of these people may be released, saying things like you can't allow foreigners to be released amongst Indian citizens. So you're looking at gross human rights violations. You're looking at Article 21 violations, which is the right to life under the Constitution of India. You're looking at indefinite detention in immigration detention camps of men, women, and children. And you're basically looking at the creation of what is the largest population of stateless people in the world today.
Darshana, 2 things to kind of add to that. When you talked about documentation getting lost, when I was in Assam last year, one of the other stories that constantly kept repeating was how many of the communities, especially Muslim communities, had moved. They've moved from one village to other because of the violence. Again, the kind of the localized communal violence that they were facing. Another thing that I really wanted to also talk about is, could you also expand on the procedural violence of how people are mistakenly being picked up and then held despite having documentation? I at least interviewed 4 families in which people who were wrongly picked up, if your name is Samira Begum and then the person who was supposed to be picked up was Shamshira Begum, and even if the ages were different, they would still pick up these people, and then again the family would spend lots of money. Again, there's a lot of detention years. Could you also talk about these 2 to kind of like explain and break down the other kind of violence that's also accompanying this list?
Absolutely. I mean, obviously, there is a question of language, which is that you're not going to have the same spellings across identity cards in India. It is almost, I think it's something that everybody who's Indian knows and understands, that name spellings change and vary widely across documentation. And often it is really the problem of the person who is registering the name. But when you hold these documents as the only proof of citizenship and identity, then that becomes a problem, because you're basically elevating clerical errors, which otherwise could have been bypassed, which otherwise could have just been ignored, and taking them to the level of, there seems to be a discrepancy in your documentation. Either one of them has to be forged. You must be a foreigner. And that has been a source of huge administrative violence. I think the other thing that I want to mention here briefly is the fact that there are actually procedures available wherein you can file objections to the inclusion of somebody's name in the NRC. The Scroll, for example, has reported extensively on how there have been 2.5 lakh objections that have been filed to the first list in the NRC, and people have had to go back, and even after going through the entire process and having their names included into the NRC, they've had to go back to the NRC Seva Kendras and say that, well, why is there an objection in my name? And clear out that objection. And often what happens is that the person filing the objection is not present. So you don't know why the objection has been filed. There is some individual who has filed an objection against your name, and then you have to go in and go through the process of proving your citizenship all over again. And I think this is another form of violence that's taking place in the state, which is completely being ignored, which is just the repetitive nature of having to prove your citizenship again and again and again.
And now can you talk to us about how the NRC relates to the Citizenship Amendment Bill?
Absolutely. I think there is, it's quite insidious, I have to say, the way in which the NRC and the Citizenship Amendment Bill play off against each other. Just give a brief background on the Citizenship Amendment Bill. What it does is that it essentially creates a shortcut to citizenship for persons of religious minorities, namely Hindus, Sikhs, Parsis, Jains, Buddhists, and Christians, from the three Muslim majority neighboring countries of Pakistan, Bangladesh, and Afghanistan. The stated purpose behind this particular proposed amendment has been that these communities are facing religious persecution in these countries, and therefore India should offer them protection. Uh, and of course, there's a joint parliamentary committee report that backs up this particular assertion. I think everybody should take a look at that report to understand how laws can be passed when close to half of your committee has decided to protest against this law being passed or framed in the first place. But I think what's important for us to ask are several questions, namely, why is there an exception being created for persons of religious minorities or from Muslim majority countries? India is not a signatory to the Refugee Convention and therefore as always has had an ad hoc approach to refugee protection. Case in point would be the protection that we offered to Tibetan refugees or Sri Lankan Tamil refugees. But this particular protection, this particular amendment seems eerily similar to the BJP's 2014 electoral promise that India will be a safe haven for Hindus. It seems to be a move towards excluding Muslims from acquiring citizenship because they have other countries which are namely Afghanistan, Pakistan, and Bangladesh to go to. But these minorities don't have other countries to go to, and more importantly, India is a natural home for them in South Asia. And when you pitch that idea against the NRC, which is an exclusionary concept, which is looking at people who have lived in the country for years and years and years, for scores of years, but are now being told that you're not actually a citizen of this country, that creates this interesting picture of citizenship where you're cherry picking communities who may never have lived in India or may have only lived in India for 5 years or 6 years, and you're saying that by virtue of your ethnicity and by virtue of your background, you automatically acquire citizenship in the country, and then you're excluding communities who have lived in the country for far more number of years, and you're saying because of you're not being able to prove your documentary citizenship, we are going to put you in indefinite detention. It is, in my mind, that definitive move from birthright citizenship to an identity, ethnicity-based citizenship. And I think that I'm not the only one saying this. There are other scholars also who have pointed out the eerie similarities between the Citizenship Amendment Bill and Israel's Law of Return, saying that what you're essentially creating is an Indian law of return, which excludes Muslims from being able to ever avail of it. And I think ideologically and principally what it does is that you essentially end up saying that Muslims do not have a lesser right to citizenship in India than other communities. Apart from the fact that if it passes, if it goes through, it will be challenged on the grounds of Article 14, which is the right to equality in the Constitution of India. The very fact that instead of signing the Refugee Convention and signing and ratifying the Refugee Convention itself, which would then allow us to decide on a case-by-case basis who has been persecuted and give them protection, we are singling out specific communities and removing other communities from the ambit of our protection, gives out a very specific message about who we consider natural citizens of the country and who we don't consider natural citizens of the country.
Darshana, coming to the end of the segment, I really want to ask the question that's been in everybody's mind. Can the NRC be extended to the whole country? And if that indeed happens, because a lot of the current BJP ministers and other RSS leadership has actually openly said that they will extend it to the rest of the country, what would be the implications of this?
Well, first of all, I don't know how you can extend the NRC to the whole country and not create an epidemic of statelessness. One has to remember that the NRC is bad, but the NRC has a later cutoff date of 1971. If the NRC, a cutoff date which does not apply to the rest of the country, it only applies to Assam. If the NRC were to be implemented in its current form to the rest of the country, it would technically have to use 1951 as the cutoff date, which is when the actual census took place. I don't think there are too many people in this country who can establish the genealogy in this country with documentary evidence to 1951 and before that, I think it would be a very, very high standard for anybody in this country to prove. Therefore, I believe that the chances of the NRC being implemented in its current form are quite bleak, unless and until, well, we want three-fourths of the country to just be declared stateless. Um, However, I do think that that doesn't prevent, for example, the government from principally looking at identifying people they consider to be illegal migrants and going after them. I don't think that prohibits, for example, a policy of electoral roll updation, which specifically takes out certain communities, targets certain communities, and leaves out certain communities. And I think that the NRC is in its current form, while it is unlikely to be implemented across the country, regardless of what politicians may be saying, there are other ways and other means by which statelessness can be created and communities can be targeted and declared not citizens of the country. And I think that's really what we need to be concerned about. I think the other thing that we need to be concerned about is immigration detention. It is a huge problem in India. It is the number of people who are being detained in immigration detention camps is enormous at this point of time. It is only going to expand. The government is pumping money into the creation of immigration detention centers. When we're looking at the United States and the way in which detention centers are operating, India is definitely not better. In fact, it is infinitely worse. And I think it's a humanitarian crisis that is not being focused on at this point of time. And if you're going to have something like the NRC being implemented in other states, you're going to have immigration detention centers being set up in other states. That is going to be a disaster of different proportions entirely, and one that we're simply not prepared for at this point of time.
Darshana, thank you for joining us. And
thank you so much, Suchitra.